to the play area. She will register the children in the register and give them name tags. She remembered the complainant and another boy child brought to the play area by their mother. However, she cannot recall the total number of children who were brought by their parents to the play area, as it was a busy day on that day. When a person is seated in the table, which is outside the restaurant on the veranda, he or she can be in a position to see a person playing in the play area, depicted on photo number 5 of Exhibit C3. Mr. Novo was working alone on that day, minding the children in both play areas. She took her lunch break at 1600 hours and asked one lady who was working at the pizza section of the restaurant to mind the children on her behalf while she was on her lunch break. As she was walking out of the playing area, she was following the complainant who requested to go and use the female bathrooms. She saw the complainant entering the bathroom and she proceeded to the place where she went to enjoy her lunch. As it was a busy day, she only utilized 15 minutes of her lunch break and went back to the children's play area. When she arrived there, she found only a boy child who was in the company of the complainant alone. She asked him, "Where is the complainant?" And he told her that she went to the bathroom. It was not long after that when the complainant's mother arrived there inquiring about the whereabouts of the complainant. They both, Mrs. Ngove and the boy child, responded by saying that the complainant is at the bathroom. However, the mother came back to her and informed her that she could not find the complainant at the bathroom. The mother of the complainant also had harsh words for her, saying that she entrusted her with a child, but she did not take good care of the child. She, together with the mother of the complainant, went to the bathroom to look for the complainant. When she arrived at the bathroom, she found Miss Dlamini there combing her hair, and she asked her if she hasn't seen the child, and she said no. She then knocked on the door of the middle cubicle, as the cubicle on the right was locked, as it was out of use at that stage, and the one on the left was open and was for the use of people living with disabilities. After she knocked at the middle cubicle, there was no response coming from the inside. She then pushed the door with the aim of opening it, and then somebody from inside pushed back the door without uttering a word. She was then assisted by one of the waitresses who was there and the mother of the complainant to push the door. The door was eventually opened, and the person she saw inside was the complainant. As the person who was pushing back the door, the door was eventually opened, and the person she saw inside was the complainant, as the person who was pushing back the door was behind the door. When she saw the complainant was wearing a skirt, whereas at the time when she registered the complainant at the children's play area, she was wearing a pair of purple tights and a skirt. The accused on his upper body was not wearing any clothing, and at the bottom or lower part of his body, he was wearing a pair of trousers, but his trouser zip was open. Prior to the accused going to the women's bathroom, she did not see the accused. Immediately after the door was opened, she saw the accused having a belt with him and delivering a blow at them with a belt in an attempt to assault them with that belt. She did not see any person being struck by that belt, and she ran away. The complainant's mother then took the child away. Fourth witness for the state was Puseletso Elizabeth Matoha, who was also at the time of the incident employed at Dros restaurant as a waitress. She saw the accused when he arrived at Dros restaurant, even though she is not the person who assisted the accused with his orders. She also saw the complainant while she was playing at the children's play area, and she was in the company of a little boy. On the day of the incident, she went to the children's play area where she was in the company of Ms. Ngogo, the childminder, and she was in her company for a period of approximately 15 minutes. While she was still with Ms. Ngogo, the complainant's mother arrived, inquiring about the whereabouts of the complainant. She was not present when the complainant left the play area. Ms. Ngogo told her, the complainant's mother, that the complainant went to the bathroom. The complainant's mother went to the bathroom looking for the complainant, but she came back screaming that she cannot find her child. Then Ms. Ngogo went to the bathroom with the complainant's mother. She could then hear the complainant's mother shouting that she cannot find the child. She then also went to the bathroom to look for the complainant. She found Miss Tamene combing her hair, but she told them that she did not see the complainant. They then knocked on the door of the middle cubicle, but there was no response, and then they knocked for the second time. There was no response as well, and then they decided to push the cubicle's door with the aim of opening it. That is when she realized that there was somebody inside the cubicle who was pushing back the door. When the door was open, she saw that person who was pushing back the door from inside, that he had a belt with him, and that person wanted to hit them with that belt. But the person only made one attempt. That person was the accused in this matter, and so the complainant standing on the right side of the accused. The accused at the time was not wearing any clothes on his upper body, and on his lower part of his body he was wearing a pair of trousers with its zip open. The fifth witness in this matter was the complainant in this matter. Because of her age and the fact that she is a child witness, I will refrain from giving out her name, and I will refer to her in my judgment as SK. SK testified through the assistance of intermediary Miss Mdijwa. SK was born on the 7th of November 2010, and she's currently 8 years, and at the time of the incident she was 7 years old. SK initially, when the prosecutor started leading her in examination in chief, it appeared to me that she did not understand what was happening. I'm saying this because in her response to questions, she was saying that she does not understand and she does not remember. However, after a concerted effort from the prosecutor, she testified that on the day of the incident, when she was heard by a male person, she is the one who first went to the female's bathroom, and that person found her already inside the toilet cubicle. On that day, she was wearing a skirt, a pair of ties, and a blue T-shirt. While inside the toilet, she heard her mother calling out her name, but she could not answer as the person she was inside the toilet with threatened to kill her if she answers. At that time, she was scared that the person. At that time, she was scared, and that person had hurt her. The mother of the complainant also testified, and for the same reason I gave for SK, I'll refer to her in my judgment as NK. She also testified in the intermediary room with the aim of protecting the identity of SK. She confirmed that on the day of the incident, she went with SK to Dros restaurant and registered her at the children's play area. At a later stage, when she was looking for her, she was informed by a child minor that she went to the bathroom. She went there looking for SK, but she could not find her. She then went back to the play area to inform the child minor that she cannot find SK. That is when she went back again to the play area to inform the child minor. Then they went to the toilet where they pushed open the door of the middle cubicle. When she called out the name of SK, SK responded by saying, "Mama, come and help me." The person who was pushing back the door, when they were pushing it open, said to them that you are disturbing me. The person came out running, and he was naked, and at that stage, he went to the male's bathroom. She followed that person to the male's bathroom and found that person wiping his penis off with SK's panty. SK was at that stage only wearing the skirt and the T-shirt. Her pair of ties and panty were missing. NK managed to identify SK's clothes on photos C4, C5, and C7, and also the accused belt, which was lying on the floor. The accused picked up SK's clothes by the time he was picking up his clothes and running away to the male's bathroom. As the person was running away, he assaulted the child minor with the buckle of the belt on her face on 2 occasions, and that happened inside the female's bathroom. NK saw the person flushing SK's panty in the toilet pan, and she asked him, why is he doing that? but that person never answered him. When she picked up SK, she realized that her skirt has blood. However, she did not examine SK to determine where is the blood emanating from. The aforesaid skirt was then handed over to the police the following day of the incident. That concluded the evidence led on behalf of the state, and after the evidence of NK, the state closed its case without further calling witnesses. The accused, on the other hand, closed his case without leading evidence or calling witnesses. It is tried that the state must prove its case beyond reasonable doubt. There is no obligation on the accused person to prove his or her innocence. The proper approach was adopted by Nugent J. in the matter of State versus Van der Meyden, 1999, Volume 1, SACR 447, when dealing with the onus of proof in criminal cases, and observed at page 448, paragraph F to G. The onus of proof in a criminal case is discharged by the state if the evidence establishes the guilt of the accused beyond reasonable doubt. The corollary is that he is entitled to be acquitted if it is reasonably possible that he might be innocent. In bracket C, for example, R versus Default, 1937, AD 370 at page 373 and 383, close bracket. These are not separate and independent tests, but the expression of the same test when viewed from opposite perspectives. In order to convict, the evidence must establish the guilt of the accused beyond reasonable possibility that an innocent explanation which has been put forward might be true. The two are inseparable, each being the logical corollary of the other. Close quotation. In State versus V, 2000, Volume 1, SACR 453, SCA at page 455, paragraphs A to C, Zulman J.A. observed, it is tried that there is no obligation upon an accused person where the state bears the honors to convince the court. If his version is reasonably possibly true, he is entitled to his acquittal even though his explanation is improbable. A court is not entitled to convict unless it is satisfied not only that the explanation is improbable, but that beyond any reasonable doubt it is false. It is permissible to look at the probabilities of the case to determine whether the accused version is reasonably possibly true, but whether one subjectively believes him is not a test. As pointed out in many judgments of this court and other courts, the test is whether there is a reasonable possibility that the accused version may be true. Close quotation. The criminal law, in bracket, Sexual Offenses and Related Matters, close bracket, Amendment Act 32 of 2007, defines sexual penetration as follows. Sexual penetration includes act which causes penetration to any extent whatsoever by A, the genital organs of one person into or beyond the genital organs, anus or mouth of another person. B, any other part of the body of one person or any object, including any part of the body of an animal, into or beyond the genital organs or anus of another person. Or C, the genital organs of an animal into or beyond the mouth of another person. The accused has already indicated he admitted sexually penetrating the complainant with penis in her mouth, and after finishing doing that, he sexually penetrated the complainant by setting his finger into the vagina of the complainant. In my view, this stands as proof of sexual penetration of the complainant by the accused. The complainant, due to her age, cannot be viewed to have consented to such sexual penetration. In argument, Ms. Komeni, on behalf of the state, contended that this court must draw an inference that the accused actions on the day, In argument, Ms. Komeni, on behalf of the state, contended that this court must draw an inference that the accused actions on that day were premeditated, and he wanted to have sexual intercourse by all means at any place, and most importantly, he wanted to prey on the girl child for the following. 1, Accused, when he arrived at Dros restaurant, he was given a table next to the door which was marked as X on the sketch plan by Ms. Ndlabeni. 2. However, when he was served with a beer order he made to Ms. Ndlabeni, he was no longer sitting at table marked X, but moved to a table which was marked X1 on the sketch plan by Ms. Ndlabeni. 3. That the table marked X1 was a distance of 4 to 5 meters from the children's play area, and the person sitting at that table can have a clear view of the play area. 4. The accused followed the complainant to the bathroom. Mr. Albert, on behalf of the accused, contended that such inference is not justified by evidence before court, and I must refrain from drawing such inference. The undisputed evidence before me is that when the accused arrived at Ross restaurant, he was allocated a table next to the restaurant entrance. He moved from that table to another table which is near the children's play area without informing Ms. Ndlabeni, who was assisting the accused at that stage. He later on moved from that position to the bar area, where he was joined by Mr. Fori. He was also at some stage seated with a woman and a young man who were seated next to the pizza area. Ms. Ndlabeni inquired from the accused as to why he was moving from the table he was initially allocated, and he replied by saying that he moved to X1 so that he can see the person he was supposed to meet at the restaurant. According to the accused, that person was a female, and he used the word she. However, we know that the person the accused met was Mr. Fori, who introduced to Ms. Ndlabeni as his uncle. There is no relationship between Mr. Fori and the accused, as Mr. Fori testified that he was seeing the accused for the first time on that day, and they met at a parking lot next to Pick and Pay supermarket. The accused also made utterances to the manager and Mr. Fori that he wanted to have sexual intercourse with the woman who was in the company of the young man. The complainant herself testified that she requested to go to the bathroom, and when she arrived there, she did not find the accused. She entered the toilet cubicle and sat on the toilet pot and relieved herself. Not so long thereafter, the accused arrived, and he had her. Evidence is not clear whether at the stage, that is when the accused arrived at the bathroom, the cubicle door was closed or open. The accused, in terms of his plea explanation at paragraphs 10 and 11, stated the following. After I had some liquor, I felt nauseous and went to the toilet to take some more drugs. I felt paranoid and feared that the manager of the establishment was aware of that. I was under the influence of drugs. I felt that the manager could cause trouble for me if I was found using cat. In the result, I went to the female toilets, hoping that he would not find me there, and entered one of the cubicles. I lowered my pants in order to create the impression that I was using the toilet and proceeded to take more cat. I had also taken off my shirt to freshen it up since the shirt was damp and sweaty. While I was busy taking cat, the complainant pushed the door. The complainant indicated that she wanted to urinate, and I got off the toilet, pulled her pants down, and put her on the toilet. From the above, it's clear that according to the accused, when the complainant arrived at the bathroom, he was already there. The accused did not testify in his defense. In the matter of State versus Busak, 2001, in bracket 1 SSCR, in CC at page 10, paragraph 24, Langa DP, when dealing with the right to remain silent at trial stage, observed. It arises again at the trial stage when the accused has the right to be presumed innocent, to remain silent and not to testify during the proceeding. The fact that an accused person is under no obligation to testify does not mean that there are no consequences attaching to a decision to remain silent during the trial. If there is evidence calling for an answer, an accused person chooses to remain silent. In the face of such evidence, a court may well be entitled to conclude that the evidence is sufficient in the absence of an explanation to prove the guilt of the accused. Whether such conclusion is justified will depend on the weight of the evidence. Close quotation. See also, in bracket, see also Osman and another, versus Attorney General Transvaal 1998, Volume 2, SACR 493 in bracket CC close bracket. The accused knew immediately when the state rejected his plea on the sequence of events, most importantly as to whether it is the child who first went to the bathroom or not, that there is a case for him to answer on this aspect, but chose to remain silent and gave no explanation of what actually transpired. I'm alive to the fact that the complainant is a single witness on this aspect, and most importantly, she's a child witness. Our court's approach is that evidence of children must be approached with caution to reduce the dangers inherent in such testimonies, where especially children are single witnesses. It is also so that our court approach is that there is no absolute requirement for such evidence to be corroborated. In bracket C. Woji versus Santam Insurance Company Limited, 1981, Volume 1, SA 1020 in bracket A close bracket. The court must, however, be satisfied that child's evidence is trustworthy. I'm further alive to the fact that when the child started testifying, she seemed not to remember the events of the 22nd September 2018. This can mainly be attributed to the fact that she was very young when this incident happened, and also for the period of time which lapsed since the incident and when she came to testify. However, as the proceedings were continuing, she remembered the events of that day, and she was in a position to can remember what transpired. I must pause to mention that cross-examination on this aspect came to nothing, and it was only put to the complainant that she is making a mistake. She found the accused inside the toilet, which was emphatically denied by the child. In the matter of President of the Republic of South Africa versus South African Rugby Football Union and others, 2000 in bracket 1, SA volume, page 1, paragraph 36, the Constitutional Court observed, the institution of cross-examination not only constitutes a right, it also imposes certain obligations. As a general rule, it is essential when it is intended to suggest that a witness is not speaking the truth on a particular point to direct the witness' attention to the fact by questions put in cross-examination showing that the imputation is intended to be made, and to afford the witness an opportunity while still in the witness box of giving any explanation open to the witness and of defending his or her character. If a point is in dispute is left unchallenged in cross-examination, the party calling the witness is entitled to assume that the unchallenged witness testimony is accepted as correct, close quotation. I am of the view that this aspect was not effectively traversed by the accused under cross-examination of the complainant, and it must be taken as admitted by the defense. This court, when drawing an inference as to the correct sequence of events of the date of the rape incident, will be guided by the dictum which was adopted in the case of R versus Blom, 1939 AD, 188 at page 202 to 203, where the court in that matter observed, in reasoning by inference, there are two cardinal rules of logic which cannot be ignored. One, the inference sought to be drawn must be consistent with all the proof facts. If it is not, the inference cannot be drawn. Two, the proof facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. If they do not exclude other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is correct. Close quotation. In bracket C also, State versus Rady and others, 1996, volume 2, SACR, volume, page 1, in bracket AD, close bracket. The proven facts in Kasu are the following. One, that the complainant was playing in the children's play area. Two, at some stage she requested to go to the bathroom. Three, accused moved tables, and at some stage she moved to the table which was next to the children's play area. 4, the accused went to the female's bathroom, where he was found naked inside the same toilet cubicle with the complainant. 5, The complainant was not wearing a pair of tights and a panty at that stage. 6. The accused, before he went to the female bathroom, he was already in possession of drugs. There is no specific reason which was given by the accused as to why he chose to sit in a table which was closer to the children's play area, as he refused to testify in his defense. There is again no specific reason as to why the accused made utterances that he wanted to have sexual intercourse with a woman who was in the company of another man. There is also again no reasonable explanation why the accused went to the female bathroom, whereas there was a designated bathroom for the males. The only reasonable inference the court can draw based on the proof facts is that the accused saw the complainant playing at the children's play area. He saw the complainant when she went to the bathroom, and he then followed her to the bathroom where she undressed her and eventually raped her. The version put forward by the accused that he first arrived at the female's toilet and the complainant arrived there after him is rejected as false beyond doubt. The learned author C.R. Steinman, in his book Criminal Law, 5th edition at page 455, defines the crime of assault as follows. Assault consists in any unlawful and intentional act or omission. A, which results in another person's bodily integrity being directly or indirectly impaired, or B, which inspires a belief in another person that such impairment of a bodily integrity is immediately to take place. Ms. Dlamini, who is a complainant in this count, testified that after the door of the cubicle was pushed open slightly, accused delivered a blow with a waist blade he was holding with his hand. The belt did not hit her, and thereafter she ran away. She did not see any person hit by that belt. Ms. Matoha's account in this count is that when the door of the cubicle was open, the accused was swinging the belt above his head. In her evidence, she never mentioned the accused delivering any blow to either herself or the people who were in her company. The child minder, Ms. Novo, gave a different account of what happened under this count. She said that the accused delivered 2 blows, but neither of the blows hit any person, and she was also not hit by the belt. The complainant's mother gave a completely different account of what actually transpired. She testified that the accused assaulted Ms. Novo on 2 occasions with the buckle side of the belt on her face before the accused ran to the male's bathroom. I'm saying that is a complete account of what happened, as Ms. Novo. When she testified, she never mentioned that she was assaulted with a belt by the accused. I'm not satisfied that the state discharge is honest under this count, and the accused is entitled to his acquittal under this count. The state discharge is honest in proving the charge of rape, possession of drugs, and defeating or obstructing the administration of justice against the accused for the reason that I have stated above. Having said so, I will return the following verdict. May the accused stand up. Rape, you are found guilty. 2, possession of drugs, you are found guilty. 3, assault, you are not found guilty. 4, defeating or obstructing the administration of justice, you are found guilty. Yes. Yes. Yes, Mr. Alves.
My Lord, at this stage, it will be necessary for the defense to get probation officers' reports regarding the background of the accused. I'm also in the process of trying to get, and it should happen, a psychologist report regarding the accused. My Lord, usually a probation officer's report would require 6 to 8 weeks. Your Lordship has indicated your Lordship would prefer to finalize this matter earlier. We've agreed, pending your Lordship's agreement, to the 16th and 17th of October, and then my learned public will request the Department of Social Work to expedite the report, if that would be suitable, my Lord.
As the court pleases, my lord, it is so confirmed, 16 and 17 October for the pre-sentence report as well as the victim impact report.
Are you in communication with the officers?
That is correct.
Have they given a guarantee that it will be finalized?
I've spoken to them, then they said by the 16th.
Yes, I don't want this matter to be postponed to this. Just make sure that we get it.
I've spoken to them, I've indicated the agency that is needed in this case, and they have confirmed that by the 16th it will be.
Yes. Yes, Mr. Ninja. Your counsel is requesting for a fulfillment to pay a probation officer support. The state also wants to pay the victim impact report. It must be complied by social workers. It is for that purpose that your matter is postponed to the 16th to the 17th of Where are the court orders? Your matter is postponed to the 16th October 2019. You don't agree to remain in that.
Order, please.
Order, Judge.